Hello.
Jason?
Hopefully you can hear me. Yeah, can you hear me all right?
Yes, we're hearing and seeing you fine.
Excellent.
Great. Thank you very
Excellent.
much.
Well, it's great to be with you all, and thank you very much for your invitation to speak at this conference, which has been very interesting so far. Yes, it's the evening now, and I had a pre-existing arrangement, so unfortunately I have to finish by a particular time. Anyway, I will share some slides. Hopefully, I will hopefully you can see some slides which are going to appear in a minute on here we go. Can you see them? Yes. Consumer enforcement and redress in the UK. So I'm a legal director.
We can see.
Excellent, thank you. Yes, so I'm a legal director in the Competition and Markets Authority, and I've been doing this sort of enforcement work for some years now, and I wanted to tell you about our regime that exists in the UK, and hopefully you'll find that helpful. So I'm not going to talk a great deal about specific CMA investigations, but I will mainly focus on the legislative framework. But if people have questions about our cases, then I'm sure I'd be very happy to answer them. So let's have a look at the legal framework. So the legal framework which we use consists of a number of components. So the one which is important is the overarching enforcement framework, and that's set out in the Enterprise Act, Part 8 of the Enterprise Act, which provides the main vehicle for civil. What this effectively allows us to do is to seek an order which is very similar to an injunction to stop businesses from engaging in practices which we think infringe the law, and also to secure redress for consumers who are affected by that misconduct. Now, there are, in addition to that overarching piece of legislation, which allows us to enforce really a huge number of pieces of law, there are a number of other specific pieces of legislation which give either a means towards redress or enforcement by enforcers, or they give people private rights which individuals can enforce privately. So probably the most significant in terms of cross-cutting law is the Consumer Protection from Unfair Trading Regulations, and that sets out a number of criminal offences, and it gives private rights of redress for some of those, where consumers enter into transactions or pay money because they've been misled, actively misled, or they've been a victim of an aggressive practice. So that piece of law we can also enforce under the Enterprise Act, and we can, if we wish to, bring criminal prosecutions. The CMA, I have to say, almost never brings criminal prosecutions, and I'll come on to the reasons why shortly. There are also some other important pieces of law. The Consumer Rights Act, which provides contractual rights for goods, services, and digital content. So in consumer contracts, it replaces the Sale of Goods Act and the Supply of Goods and Services Act. So some people who have been practitioners for a while in Commonwealth jurisdictions may be familiar with the Sale of Goods Act or the Supply of Goods and Services Act, but those no longer apply in the consumer context. And Part 2 of that Act governs unfair terms, and similarly, that replaces in the consumer context the Unfair Contract Terms Act that people may be familiar with. And then there's the Consumer Contracts Information Cancellation and Additional Charges Regulations. And that gives people cooling off rights, a right to information, control over surprising charges, and so on. And importantly, that gives people the right to get their money back if certain circumstances arise. So, for example, if they're not given the right information, or they just decide they want to end the contract within a 14-day cooling off period, they can have their money back. There are also numerous other rules on things like product safety, package travel, timeshare, consumer credit, which there just isn't time to go into in this short presentation, but they also provide people with certain rights to redress, which are important and can also be enforced not only individually, often there's criminal offences attached to some of these provisions, but also under the Enterprise Act. And the power of the Enterprise Act really is that it enables enforcement for a multiplicity of breaches. So we don't have to just show that something is a criminal infringement under the Consumer Protection Regulations, for example. we could say, well, we think it's an infringement of that piece of law, and it's a breach of the Consumer Credit Act, and it's an unfair term, and we put it all into one piece of litigation, and off we go. So that's the overarching legal framework. I should say that our law, all of this law, is largely derived from EU consumer law. And as people, of course, know, the UK was a member of the European Union until recently, and therefore most of our consumer policy thinking has been conducted in the context of the EU. And so the substantive consumer protections which exist in the UK are generally the same across the European Union. Now, as of course, we've left the EU and legislation is developing separately, there will be some divergence, but so far the law remains, broadly speaking, comparable and very, very similar, if not exactly the same. The importance of this, though, is that when we're construing our law in the UK, we will still, and I suspect for some years, be having regard at least to European legal principles, the approach of the European Court of Justice, and how the law was intended to, what was the policy intention of the law when it was drafted originally in that European context. So, for example, principles like the high level of consumer protection and so on. Well, who enforces in the UK context? Well, there's a number of enforcement authorities, many enforcement authorities. And so I give a brief sort of scheme of who does the enforcement. So, of course, starting off with my organisation, the Competition and Markets Authority, we aim to carry out cross-sector enforcement of issues which are important to the UK economy kind of overall. We're not particularly focused on any particular sector, and we leave local enforcement to local trading standards. And the reason for that is because in most of the kind of specific sectors of the economy, there are sector-specific regulators who have comparable powers. So either they have administrative fining powers, or they'll have licensing powers, or they can bring enforcement action under the Enterprise Act, which I've described. So those would include the Financial Conduct Authority, which regulates in the financial services sector. There's Ofcom in the telecom sector. There's the Civil Aviation Authority, and I've written etc. because there are many others as well. And each of them have their own rule book, their own set of powers, and those powers can be quite different. And so the way the CMA tends to operate is that we will have memoranda of understanding with different organizations, and we would tend to defer to them first of all, so that they have a go at sorting out the problem. But we are not prevented from taking action if we feel we need to. And for example, one of the sectoral regulators is not doing something, and we feel that perhaps it would be better if enforcement takes place. Well, we have the power to do that. And then, of course, there's local trading standards. So local trading standards are the main enforcer of consumer law in the UK. They have by far the largest chunk of the budget, as it were, for consumer enforcement, and they will ensure general compliance across the economy. So routine enforcement, for example, of a trading standards infringement. So, a business that hasn't got its unit pricing right, or a business which is delivering short measure local trading standards, subject to their resources and the other constraints on them. They will carry out inspections. They tend to prosecute infringements, but they also carry out important work as so-called primary authorities. And that's a system whereby they give something called assured advice to businesses, which the business actually pays for. But the Trading Standards Authority will give them assured advice, and that means that if the trader complies with that advice, they know that they're not going to face enforcement action from that authority, and they'll have a primary authority relationship with a particular trading standards department. So anyway, this is all slightly complicated, but the main thing to get across is that trading standards do most of the enforcement, and depending on which jurisdiction you're from, it may be that many of the authorities perhaps who are on this call may have an enforcement practice which is more similar to trading standards than it is to the Competition and Markets Authority, because that's about compliance. And I'll explain in a moment more about how the CMA approaches its work. And then there are some statutory redress schemes. So these are schemes which are set out in legislation. Businesses which are in the particular sectors are subject to those redress schemes. You know, they don't get a choice. So two examples of financial ombudsman. So if you're a regulated financial services provider, then you are subject to the jurisdiction of the financial ombudsman. And if you don't treat your customers as they might expect to be treated, they can bring a complaint to the financial ombudsman. The financial ombudsman can adjudicate against you, and you have to satisfy whatever the adjudicator says. And it's a similar system in the estate agent system. For example, estate agents have to be members of a redress scheme. They have to be in a code, and the code provider will adjudicate. And there are various other statutory redress schemes. And then there's what you might call self-regulation. So there's the Advertising Standards Authority. They adjudicate against misleading advertising, but they have a kind of quasi-statutory basis. They're not entirely self-regulatory because they carry out various functions on behalf of Ofcom, but they're a self-regulatory function in the sense that businesses comply with ASA adjudications because it's very difficult not to, rather than because there's a piece of legislation that makes you comply. Right? If you don't comply with the ASA adjudication, then the remedy is that the ASA will complain to trading standards, who may prosecute. And there are many other code schemes which exist where businesses have decided to set up code schemes. They may have an alternative dispute resolution scheme as part of that, and so on. So that's a broad picture of the enforcement landscape in the UK. It's quite complicated. The UK has a very developed economy, and therefore we've got quite a lot of regulators. So we do a lot of regulation. Generally, compliance in the UK is high, but the picture of who does what is quite complicated. Well, what about how do we prioritize? Well, slightly facetiously, I've suggested, well, there's a framework here. You know, do it, diarize it, delegate it, or dump it. That's how you might approach it. That's not how we do things. We apply some enforcement prioritization principles. So we don't do everything. You know, people might complain to us, or there are many things it'd be really useful for us to do. We'd love to do it, but we have limited resources, and so we are driven significantly by what will the impact of our enforcement be. And we do a lot of impact assessment. So it's heartening to hear about impact assessment. Before my little presentation, we have given a commitment to the UK government treasury that we will deliver something like £10 for every £1 of our budget. So we are intending to deliver value to the UK economy, and we carry out impact assessments of the work that we do, so that we can demonstrate that we have given that value back to the UK economy. And usually, actually, we give significantly more. So in recent years, it's been more like £25 for every £1 of our budget. So we deliver an impact of 25 times our budget. It depends on each year, you know, how much it is. So impact is very important for us. But we're also thinking about strategic significance. What's the resourcing picture look like? You know, do we have resources to do something? You know, is the work so complicated and involved it's going to require an unreasonable amount of work, or is the impact likely to be so small that it's difficult to justify the resource? Because at the end of the day, it's taxpayers' money that we're spending on enforcement and other work that we do, and therefore it's important that we give good value. And then we also think about risk. So risk in the sense that sometimes enforcement might be an attractive idea, but actually the law is quite unclear. So it may not be the best use of our time to take a business to court because we think we probably will lose in the end, let's say. So we would factor that in as well. So those are the sort of prioritization factors that we take into account. So thinking about that in slightly more concrete terms, given the complicated enforcement landscape, a lot of the time we'll be asking ourselves the question, who is best placed to act? So if we get a complaint about financial services, for example, we might think, well, it's better for the Financial Conduct Authority to look at that. Maybe it's a local matter, or it's routine in a non-compliance, so it's better for trading standards. Importantly, we're often thinking about, can we change how the market operates? Okay, we don't want to become a sector regulator for a sector that doesn't have a regulator. All right, so we're thinking about, is there something that we can do that's going to make this market work better and allow us to then exit the enforcement in that market and see how the market develops? Because there's a danger, isn't there, that we become effectively the market regulator, and that's not part of our role to do that. Our role is to make the market work well and then see how it's working, and then if we need to intervene again, back in we go. And we'll also be thinking about, well, what is the best way to achieve change? So we're not constrained just by enforcement. So as I said, we very rarely bring criminal prosecutions. And that's because in our experience, in the markets that we act within and the sorts of issues that we tend to look at, criminal enforcement is not necessarily the best way to achieve change. And that's because criminal enforcement involves punishing somebody for an event which happened in the past, rather than changing how they behave going forwards. Our civil enforcement regime is all about securing change going forwards, and that we find tends to lead to some good outcomes. But it's not even just enforcement in the sense of, well, is it criminal or civil? Sometimes the better way to achieve change is to give guidance, perhaps in a sector where it's unclear how the law should apply. A lot of the law that we use is principles based. For example, it's not specific sets of detailed prohibitions. It's principles based law, like you must not mislead consumers. You know, you have to have terms which are fair. What do these things mean? Well, we try to give guidance which explains what those concepts mean. And sometimes it's not about giving guidance, it's about doing some kind of market study or a call for information to try and understand what is going on in the sector. Or it may be we want to campaign in a sort of not a sort of big campaigning way, but maybe lobbying the government slightly for a change to the law, because we might think the law is unclear. And we could try and enforce it, but actually it'd be better if the government changed the law. For example, so there's a variety of different things that we do to try and achieve change. We have a number of investigation powers. So if we wish to go towards enforcement, these are the sorts of things which we can do. We have wide-ranging enforcement powers. So we have the power to send information notices, which are enforceable by a court order if somebody doesn't comply. We can carry out test purchases. So sometimes those are covert test purchases. We could carry out so-called directed surveillance. We can use so-called covert human intelligence sources. We're empowered to do those things. These are the same sorts of powers that the police have for doing covert investigations. And we have a range of on-site inspection powers. So we can carry out on-notice inspections, without notice inspections, and we can get warrants from a magistrate to go in, and it's an offence of obstruction if the business doesn't cooperate when we're on the premises. So we have broad powers to investigate where necessary. One of the things I haven't included in here is our market study power. So sometimes we do a study of a market, and when we do that, we have comparable information gathering powers, which are in a way even more toothy, if you like, because they carry with them direct fines. If people don't comply with an information notice in a market study or a market investigation, we can fine people quite large sums of money. And that's something which is going to be coming in the consumer side shortly, and I'll talk about that in a moment. Well, if we use the Enterprise Act, what does the Enterprise Act process look like? Well, it's designed to achieve a non-court outcome. That's the idea. The idea is we do an investigation and then we consult with the business. That's where we set out to the business what our concerns are. We say to them, look, these are the concerns that we've got. What are you proposing to do to alleviate our concerns? And they may offer us undertakings. So usually we write to them and we say, here's the concerns and here are the undertakings that we would find satisfactory. And those undertakings might include paying back money to consumers. Nowadays, usually they do. And they include a whole set of changes that we think will make the market work better. And businesses may not want to give us those undertakings. If they don't wish to give them, then the next step for us is to litigate. So we issue court proceedings. In the litigation, we can get urgent orders, we can get final orders, we can take down websites if necessary, but it's all a court-based system. And then assuming we secure an order, then there'll be a process of monitoring compliance. And also, if we get undertakings from a business, we take the compliance of those undertakings very seriously. Unfortunately, at the moment, if a business doesn't comply with undertakings that they've given, there's no consequence as such, there's no fine. But if a business doesn't comply with an order, a court order, then they can be in contempt of court. Officers of the company could go to prison, they could face large fines, and so on. So that's the current system under Part 8 of the Enterprise Act. But looking ahead, we're likely to get some amendments to all of that, some quite radical changes actually to the regime because of the Digital Markets Competition and Consumer Bill, which is currently going through Parliament. And at the moment, that's aiming to change three major aspects. So one is to update our investigation powers to some extent. So we will have the ability to fine people if they don't comply with an information notice that we send them. We'll have the ability, a clear power to send information notices to overseas parties. I mean, we consider we can do this anyway at the moment, but there's going to be greater clarity placed around that. And there will be a clear power to assist overseas enforcers in some circumstances as well. So we'd be able to use our investigation powers to assist enforcers overseas. And that's important, isn't it? That enforcers are able to work together in a cross-border context to investigate things. There'll also be some updates to the Part 8 process. So the Part 8 process is going to be rewritten. Much of it is broadly comparable, but importantly, there will be the power for the court to impose civil fines, as well as order compliance, and they'll be able to fine for breaches of undertakings. So if a business has given us an undertaking and they don't comply, not only will we be able to get an order against them, we will also be able to secure a fine for breach. But the most radical change is new powers for the CMA to enforce directly. So through an administrative fining process, we'll be able to find an infringement, not just a court, it'll be the CMA, which will find the infringement. We can then fine the company, order them to pay redress, and direct them to comply with the law in specific ways. And that will be subject to appeal to the High Court. So this is a really radical change, which is going to be coming in, and people may wish to watch the progress of that bill as it goes through Parliament and see how we go about enforcing when we get the powers. There'll be various guidances and rules which we're going to have to work on as well as that process goes on. So that's it. That's the overview of our enforcement regime in the UK. As I said, I haven't really gone into much on what the CMA does. So if people have particular questions on that, then I'm very happy to answer those. But other than that, I will hopefully stop sharing. And if anyone wants to ask a question either in the chat or directly, I'm sure, is there time? I mean, if there isn't, then you can shut me up. Thanks very much for listening.